Hello. So this presentation is about the contract of appointment between a strata manager and a strata scheme. The presentation is intended to educate viewers on what the management contract is. The target audience for this video is either those who do not know much about the strata industry at all, who want to learn more, or who are currently employed in the strata industry but just wish to consolidate their knowledge on this topic. Please leave your feedback once you've watched this video, and thank you very much for taking the time. What is it? The contract of appointment, which is also known as the management contract, the management agreement, or simply just the contract, is the agreement between the strata scheme, which is the owners of the property who are responsible for the common property, and the strata manager. So it's a legally binding document. And there is two parties that are involved with the contract. The two parties are the strata manager, which is fairly self-explanatory, and the strata scheme. As stated before, the strata scheme is comprised of the owners of the scheme, so that's basically all the owners at the property who are, as a group, responsible to ensure that the common property is maintained to an adequate standard. The relationship between the two parties is that the scheme is the entity who owns the common property and is responsible for its upkeep, but the manager is employed by the scheme as an agent of the scheme itself to undertake some tasks that the scheme has delegated to them in the contract on the scheme's behalf. So, what are the functions and the obligations of the manager? Well, arguably the functions and the obligations of the manager will change for every single scheme, and that's because every single scheme tends to operate in a different way and have different items which require maintenance by the strata scheme. The main role of the manager at its core is to manage the common property on behalf of the strata scheme. All managers are expected to comply with ethical obligations. These can vary, but some examples are to act honestly and in good faith at all times, to exercise due care and diligence in all their duties, to remain neutral and not use their position in an improper manner, which would affect their promise to act in the best interests of the scheme, and to make their best effort to acquire goods and services on a competitive basis for the strata scheme. So, we've talked about the responsibilities of the strata manager, but we haven't talked about the responsibilities of the scheme itself. I find that this one is always a bit more tricky than the manager because obviously the manager is being employed in the contract, so it's fairly obvious to assume a large amount of the duties will fall to them. However, there is still some obligations and duties that the strata scheme has to comply with to fulfill their part of the contract. So they vary between different schemes, as with the manager's duties, but some general items could be included as scheme responsibilities would be things like paying the owner's contributions and special levies that are raised by the scheme, and ensuring the manager is provided with adequate instructions to carry out tasks for the strata scheme, because obviously the manager can't carry out these tasks unless the scheme has advised them of what needs to be undertaken. Sometimes there's some additional responsibilities that may be required for the scheme. For example, the Strata Community Australia industry body, SCA-VIC, have a clause in their contract that expects a chairperson is selected to be appointed at all times. So then the manager can manage the scheme more easily and efficiently because they have one point of contact that they go to first, and that person acts on behalf of the rest of the scheme. The contract could also include a strata scheme warranty clause. At its simplicity, this clause basically verifies the manager's been appointed lawfully and under the accurate protocol and procedure that's required for that. How is the contract created? Well, when creating a management contract for a new scheme, or if the manager's been reappointed for a current scheme, the strata manager has a couple of options. They can create their own contract, or they can employ a contract law specialist to help them to do this. Now, if the manager happens to be a member of that organisation I mentioned before, the Strata Community Australia, they do have the option to use the SCA contract. So this contract is actually the best practice contract for Australia because it's been created with the advice of qualified legal professionals. Now, a strata manager who's not an SCA member and does not choose to use this contract should not create their own contract without any legal advice, because this isn't advisable as it can expose them to risk and liability. At its core, a contract will detail who is involved, that being the strata manager and the strata scheme. So the strata scheme tends to be represented in the contract by the strata scheme number, the address of the property, the scheme's Australian business number, ABN, and a representative or contact of the scheme, often the chairperson. The manager is represented by their name, their company or business name if applicable, their office address, their postal address, their licensing or registration details, and their professional indemnity insurance information. How is a manager appointed? Once a scheme is resolved to appoint or reappoint a manager, formal appointment and execution of the contract of appointment is required. Most of the time, the scheme just needs to put a standard resolution forward at their annual general meeting. The resolution should state to appoint the manager, as well as the delegation of what tasks the manager will be expected to undertake on behalf of this particular scheme. So the strata scheme as a whole is required to make this resolution. It can't be made by the committee or the chairperson. The only other party which has the power to legally remove or appoint the manager is the tribunal. If the scheme wants to modify or discuss specific contract terms and clauses, fees, or how long the contract will last, these items are sort of typically arranged prior to the formal resolution at the meeting, and they'll have had some informal negotiations or perhaps even formal negotiations with the manager prior to the AGM. The appointment of the manager is null and void unless the contract is executed in the accurate manner. So strata legislation needs to be referred to by the manager to make sure they have adhered to correct procedure. And this again varies depending on the state's strata legislation. However, typically all that's required is signatures of 2 of the strata members witnessing the contract with their personal details and the date of signing, and the application of the common seal for the strata scheme. Then this contract will need to, of course, be executed by the manager to complete the formalisation process. So, what is in and what is out? So as stated before, it varies. The contract for every property tends to be slightly different because every property is slightly different. So what also varies is what is included as standard duties for a property and what is construed as an additional duty for the manager. And these additional duties may incur an additional charge for the manager as they fall outside of the standard tasks that they would be undertaking for the scheme. So, what is in? Typical items that might be included in the manager's tasks are to circulate notices for the members' contributions and special fees raised by the scheme, actioning minor repair and maintenance issues, paying the contractors who attend to such issues or to regular maintenance at the property, arranging insurance valuations, organising and attending annual general meetings, AGMs, sending out and responding to everyday correspondence, and disclosing any commissions that are received. And they may also be asked to advise the scheme when the scheme needs a bit of assistance with regards to how they should manage the scheme. So this could specifically relate to if a scheme has a strata scheme committee appointed, the committee may want some professional advice from the manager in their capacity as the manager of the scheme. Now we come to the other question, what is out? So the contract should always list what the manager will not be responsible for, so then there's no confusion on either side over what the manager will be doing for the scheme and what they will not be doing. So on-site visits is one example. Many managers don't make regular visits to the property as they're mainly office-based, which is fine. However, if the scheme does wish for the manager to attend to the property, the contract should define how often this will be done and at what frequency. The inclusions and exclusions for the manager's duty will depend on how their management organisation operates, as well as on the requirements of the individual scheme. And it's important for the manager to be fairly flexible in this regard, because that's their best chance of winning or retaining some business. So additionally, the scheme is unable to delegate powers to the manager which exceed that of a standard resolution for the scheme. So any matters which require a special resolution or a unanimous resolution cannot be made by the strata manager or committee or the chairperson or any other delegate. They have to be made by the scheme itself. Unfair contract terms. To ensure a contract complies with the legislation, it's important to ensure that all terms included in the contract are fair and just. So the Australian Competition and Consumer Commission, the ACCC, defines what may be considered as an unfair contract terms in the consumer law. This ensures that both parties to the contract are protected if they consult this information. So some examples of unfair contract terms could be a term that enables one party but not the other to terminate the contract, or a term that enables one party but not the other to vary the terms of the contract. So obviously both of those items would unfairly benefit one party and unfairly impact or be a consequence for the other party. So if a strata manager or a scheme wants advice about unfair contract terms, they can consult the ACCC or speak to their state consumer body. So in Victoria, that would be SCA Vic, Strata Community Australia. Typically, a manager will have a set management fee for the standard, mainly administrative tasks which they undertake, and then a separate schedule for any tasks which they believe falls outside of this. So these are commonly referred to as additional services or additional tasks. So additional tasks are normally charged at either an hourly rate or they may have a specific cost applied for a specific type of job. Again, additional tasks tend to vary, much like the typical tasks, the standard tasks in the contract. However, they could include things such as attending or organising special, general or committee meetings, debt collection and tribunal attendance, meeting away from the office or outside of business hours, or resolving business notices or orders. There's many more that can be considered, but again, this will depend on the manager's personal management company and what they believe constitutes a standard task and what they believe constitutes an additional task. So, a strata manager may be authorised under a financial services licence holder. They may also receive a commission for carrying out certain duties. For example, they might arrange insurance for the strata scheme and receive a commission for arranging this insurance. The manager should include details of any and all authorisations, commissions, received or other relationships which might compromise their promise to act in the best interest of the scheme. So if they act under the services of a financial licence holder such as an insurer, or maybe they have a commercial agreement with a contractor where they receive additional benefits, anything of that sort should really be disclosed to the scheme prior to them appointing the manager, so they're well aware of what the manager is receiving. Another way to ensure that the manager is acting in the best interest of the scheme is the best practice that all strata managers hold professional indemnity insurance cover. So this is not required in all states or territories, however it's recommended because professional insurance cover may cover the scheme in the event that they're the victim to possible misconduct by the manager. So the contract needs to define the PI insurer, the policy, the expiry date, and the amount of cover for this. So there you have it, a brief overview of the contract between the strata manager and the strata scheme. If you want to view further information, I'd suggest visiting the Strata Community Australia website, or if you're in Victoria, it's SCA Vic. Or you could also seek the advice of a qualified strata manager or strata management company if you're looking for someone to manage your strata scheme. This video is part of a two-part presentation for my Certificate 4 in Strata Community Management. Part of the assessment that I'm doing right now, this presentation, is to gain feedback from viewers of this presentation. Therefore, if you have watched this presentation, thank you very much. And if you wouldn't mind, please helping me out by providing a bit of feedback by either leaving something in the comments below or alternatively filling out the survey I've created for viewers of this presentation. The link for the survey is also pasted below so you can access that. It's very short. Next week I'll be uploading a video which is going to look at the other part of the management contract which I did not discuss in this presentation, and that is terminating the management contract. That's a lengthy discussion and hopefully you'll join me to learn about that part of this topic.